Good morning, I'm Father X. In this episode, we're going to talk about how to tell if your divorce court judge is incompetent or gender biased against dads. And I have so much to cover. This is part 2 of a 3-part series. In part 1 of this series, episode 7a, we discussed the framework of how to compare the actions of a competent, neutral person versus the actions of your judge. And we talked about how the temporary orders were designed to serve the best interests of the mother and of the judge without any consideration of the actual best interests of the child. And we know the judge was acting in the worst interests of our child because after a fact-finding trial, it was determined that it was in the best interests of our child to have me, his father, primarily raise him. By the end of our prior episode, I discussed 6 points where the judge acted in the best interests of the mother and the judge 13 times. In case you're wondering, there were no instances of the judge acting in the best interest of the father or of the child. The number here isn't 0 because I'm hiding them. The number is 0 because those instances didn't exist. And the judge demonstrated incompetence or gender bias against dads 12 times. You'll see these numbers adding up. It's important to learn these tactics used by judges so that you can recognize and counter them if they happen to you. So let's keep going. Point 7. Compare the judge to professionals, our son's pediatrician. In early November of year 1, the Child Protective Services report provided input from our son's pediatrician. The pediatrician had no idea about the domestic violence issues in our home or the mother's psychological issues, because we never spoke to him about that. He was just our son's medical doctor, not our couples counselor. However, the judge was just as uninformed as the pediatrician about the domestic violence issues, so both of them had a similar lack of knowledge on this. The pediatrician was a 60-year-old man with decades of experience caring for children. Our pediatrician told the CPS worker that this was a case where each parent should have 50-50 custody. This appeared in the report to the judge. What did the judge do? The judge ignored the pediatrician's recommendation and kept rubber stamping the mother for primary custody without providing any reason. Which opinion do you think is more informed based on decades of directly caring for many children? So for being less qualified than an experienced pediatrician, let's mark one instance of the judge acting in the best interests of the mother and of the judge. And let's mark one instance of the judge's incompetence and gender bias. Point 8. Lack of a neutral starting point. In our court date in early November of year 1, when we got the Child Protective Services report, my lawyer came out making arguments to get us back to a starting point of equal custody. He said, on the last court date, the court didn't have much information regarding my client. The court now has a wealth of information in terms of the court-ordered investigation regarding my client's home, his employment, and his character as a father, and we're asking that he be given more time with the child. The mother's lawyer said, I don't believe that the court-ordered investigation gives the court any additional information to increase time. As we know, the father is with the child every single Friday to Sunday night, and the mother is with the child during the week. There's nothing in the report that, from our perspective, would seem to warrant there being more time. In fact, I think the report raises some very huge issues regarding domestic violence. I understand the father claims that the mother is the provocative one in those instances. The mother claims the other way. Obviously, Child Protective Services doesn't make a determination one way or the other. I think that the order in place right now is a very fair one to the father, given that he has the Friday to Sunday every week. If we look at a typical access order, one parent having alternate weekends and a visit during the week, it's clear that the father has even more than that. The mother's lawyer's arguments were wrong. She never bothered to state why it was in the best interests of our son to be primarily with the mother. She never explained, if there was no determination on who the perpetrator of domestic violence was, why should the mother have primary custody? And it's ridiculous to think a father should be happy with parenting every weekend because most dads get alternate weekends. The law says primary custody should go to the parent better able to meet the needs of the child. Only a gender-biased bigot would claim a father should be happy getting every weekend. But the judge nodded at the mother's lawyer's arguments. My lawyer replied with, "I take issue with what we call a typical access order. I'm not sure what that means, because not every case is typical. Not every case is the same. In this case, you have two individuals who are both parents. My client is seeking his right to his child. He wants the benefits of raising the child as well as all of the responsibilities that come with raising the child. He doesn't want to be a weekend father who then gives the full access back to the mother. That's actually insulting to him. So we're asking that he just be given what every father in his position should be given, equal access to the child. If not full custody, at least 50% custody." What did the judge say to my lawyer? She said, "I understand your point. Being that there's no consent, I'll have to hold a hearing regarding those issues." And she maintained temporary custody for the mother. What did the judge do wrong? First, the judge maintained primary custody for the mother without any actual fact-finding as to the best interests of our child. And the judge was basically saying that a father could only be considered for 50-50 or primary custody if there was a hearing, which is a gender-biased double standard. Second, the judge abdicated her responsibility to be a neutral third party when she said that without the mother's consent, the court wouldn't give the father equal parenting time. But the mother is not the decision maker here. You cannot defer this decision to her. The judge gave the mother all of the veto power, but it's the judge's responsibility to treat both parents equally. So, again, for not having a neutral starting point, let's mark two instances of the judge acting in the best interests of the mother and of the judge, and let's mark two instances of the judge's incompetence and gender bias. Point 9. Discouraging the father from moving forward. During this early November court date, the judge continued giving the mother temporary primary custody without any determination as to the best interests of the child. And see if you can find the incompetence and gender bias in the judge's statements. The judge said, and I quote, "I'll have to hold a hearing regarding those issues. It seems like this case is calling out for forensics because it's two opposing views here. I understand trying to lessen the financial impact on the parties. Forensics are not only costly, but they're time-consuming. It takes about 3 months." And then she added about custody. "I don't know how good it is there are a lot of opinions as to a child this age. First of all, what type of access should the father have? And also, with respect to 50-50, I don't know if that's always in the best interest of the child, especially as they grow up and the parties might want to live separate lives, move around in the city. So I don't know how practical a 50-50 split is in terms of schools, in terms of stability." And then she added, "I think it would be more prudent to have one hearing after forensics with the benefit of having that information. The parties have retained attorneys, so it can be expensive. And then also, I really don't know if you're going to come out in a better situation than what you're in now." Do you see how the judge discourages the father from continuing? First, despite two opposing views, the starting point is that the mother gets primary custody. Second, my petition was asking for primary custody, but she dismisses the validity of even 50-50 custody. Clearly, my getting primary custody wasn't even in the realm of reason for this judge. And also, she hit me with the, "I really don't know if you're going to come out better than your current 2 days a week." But the statements in my petition demonstrated I should have primary custody. The judge predetermined the outcome. The gender discrimination was obvious. Third, the judge talks about 50-50 being unstable for kids in school. But our son was 1 year old at the time, and school was 4 years away. There was no logistical reason to prevent 50-50 custody temporarily until we had a trial. The judge's thought process was completely disconnected from the reality of the situation. This was the garbage I had to deal with in family court. I know many fathers deal with this too. Unfortunately, these 10-minute appearances happen so fast that you don't have time for a thorough discussion or to properly react to nonsensical arguments. And early in my family court journey, I was too inexperienced to understand how to overcome the judge's nonsense. It took me about 2 years to really learn how to get around the judge's dumb statements. That's why you need to learn sooner. So, for discouraging the dad from proceeding with a trial to figure out the actual best interests of the child, let's mark another 3 instances of the judge acting in the best interests of the mother and of the judge. And let's mark 3 more instances of the judge's incompetence and gender bias. Point 10. Judge blatantly lies in court. During this early November court date, the judge continued the temporary orders by saying, and I quote, "All right, so the court orders are consistent with the best interests of the child." But we know the best interest factors. There was never any actual analysis or fact-finding about the best interests of our son. That never happened. And we know that, at the end of the trial, it was determined that the best interest of our son was to have me, his father, be his primary custodial parent. Why did the judge say the sentence? It was a marketing slogan to give the illusion that the judge was acting in the best interest of the child. But obviously she wasn't, because she never conducted the analysis to determine the actual best interests. The judge lied in her own courtroom. So let's mark another instance of the judge acting in the best interests of the mother and of the judge. And let's mark one more instance of the judge's incompetence and gender bias. Point 11. Sweeping the mother's lies under the rug. During our first appearance before our new judge in late September, I appeared with my criminal lawyer and the district attorney in the criminal case against me. And when that appearance ended, the mother came up with me in front of the same judge in the child custody case. But first, during the criminal case appearance, I had my criminal lawyer make a speech to the judge about how the criminal allegations were fabricated because the mother wanted custody, and this was the mother's way of getting an advantage on the custody case. The judge completely ignored that claim when we had to deal with custody matters a few moments later. No questions asked. And in our second appearance before this judge, in early November, the district attorney dropped the criminal charges completely. This would be a red flag to anybody, but the judge continued to ignore the topic of whether the mother was lying about being a victim of domestic violence. The appellate courts tell us that lying and manipulating the court process in order to get child custody is supposed to be weighted against the lying parent. So, let's mark another instance of the judge acting in the best interests of the mother and of the judge. And let's mark one more instance of the judge's incompetence and gender bias. Point 12. Giving the mother veto power. In late November, we had another appearance. My lawyer started with, "My client has access Friday afternoon to Sunday, as the court will recall. It's clear at this point that since the beginning of that order, my client and the child have bonded well, and my client is asking for increased time, if not an alternating Wednesday setup, where he can have the child Wednesday to Sunday. We're asking for a Thursday night drop-off and pick up Sunday. My client is employed, but can certainly work from home as an arrangement he made with his employer to work from home on Friday. He'll be with the child on Friday." The judge then deferred to the mother's lawyer, who said, "There's no consent to increasing the access schedule." The judge decided, "I'll leave everything status quo pending a hearing. What's the status of forensics?" And that was it for discussing temporary orders on custody. What did the judge do wrong? First, there was again no analysis of the actual best interest of the child, but the mother gets temporary custody anyway. Second, the judge restated that a father can't have 50-50 or primary custody without a hearing. Third, the judge abdicated her responsibility to be a neutral party when she said that, without the mother's consent, the court wouldn't give the father equal parenting time. The mother is not the decision maker. You cannot defer this decision to her. The judge already engaged in these behaviors during our prior court appearance, but for doing it again, let's mark another 3 instances of the judge acting in the best interests of the mother and of the judge, and let's mark 3 more instances of the judge being incompetent and gender biased. Point 13. Judges make hollow speeches. Towards the end of the late November 10-minute appearance, the judge and lawyers were discussing if we should move forward with a forensic evaluation. The judge made a little speech that I want you to think about and evaluate. The judge said, and I quote, "The forensic evaluation process is very costly, time-consuming, very invasive. So if there's any way this case can be settled without the necessity of your going through that process, I welcome that, and I think you would also. Considering, since you're already involved in litigation here, you have the child support issue going on, so it's just another layer of that court process that you're going to have to go through. It doesn't sound as though you're very far apart." And then the judge continued, "I'm glad to hear the visits are going well. I consider the issues placed on the record to be minor on the scale of what I usually hear in this court. So to me, it doesn't sound as though you're really that far apart. It's better if you're able to resolve the issues without the court having this hearing, especially since you're not very far apart." What did the judge do wrong? First, she asked us to settle, but she gave the mother primary custody and all the power to deny me even equal parenting time. The judge made it impossible to settle for something in the actual best interests of the child. The judge asking us to settle was an underhanded and meaningless request. The judge was putting on a fake act, pretending it's better for the parents to settle, when the judge has given the mother all the negotiating leverage for no legitimate reason. Second, the judge said we were not very far apart, but this was idiotic because we each wanted primary custody. You couldn't be further apart unless you each wanted sole custody. Third, the judge was glad visits were going well, which only refers to the father's visits. But she was ignoring the elephant in the living room, that our child was in the primary care of a violent, abusive, knife-wielding, borderline mother. The judge was only concerned about the father's parenting, but ignored the fundamental problem with the mother being the primary parent. Fourth, the judge considered the issues in this case to be minor on the scale of what she usually hears in this court. But again, our child was in the primary care of a violent, abusive, knife-wielding, borderline mother. It's easy to think there are no major issues when you actively ignore everything the father says. So, for making a hollow speech that doesn't address the best interest of our son, let's mark another 4 instances of the judge acting in the best interest of the mother and of the judge, and let's mark 4 more instances of the judge's incompetence and gender bias. Based on these 13 points, we can now see the judge has acted in the best interests of the mother 28 times, in the best interests of the judge 28 times, and we can see the court has demonstrated incompetence or gender bias 27 times. We'll conclude this 3-part series in the next episode, 7C. These might be the darkest days of your life. They were for me. I'm making these educational videos to help you navigate this nightmare. If you subscribe, you can get updates when I post more videos. Thank you for liking, subscribing, and sharing with your friends who are in a similar situation. If you like, subscribe, and share, it'll also help the YouTube algorithm get this message out to more fathers in our position. Also, if you find this information helpful, please support this channel so I can make more videos. You can donate via my YouTube channel's About page using PayPal or Venmo.